well spoken today. All right. Case number 2 on the docket is case 2380. TBR Small Riverside Jacksonville Owner LLC versus Andrew Gwinoit and Thomas Borchert. I apologize if I'm mispronouncing anybody's name. Just for informational purposes for our audience, as of the first of the year, the 5th District Court of Appeal got realigned and we acquired what's called the 4th Judicial Circuit, which is Duval, Clay, and Nassau County cases. This is one of those. So this is one of our early oral arguments of a Jacksonville case, for lack of a better term. So we're, again, happy to welcome Jacksonville and the 4th Circuit to our court, and hope we pass your audition. All right, counsel, go ahead. Five minutes okay for rebuttal?
Yes, Your Honor.
All right.
And good morning, and may it please the court. My name is Jonathan Martin, and I represent the appellant, TBR. This court should reverse the trial court's order granting final summary judgment because, first, it is Florida law, not Virginia law, that applies to the substantive issues in this case because the appellees, as non-signatories to the contract, cannot enforce the choice of law provision.
Well, let me ask you that. So do you then concede if Virginia law applies, your side loses?
If Virginia law applies in that the choice of law provision applies and the entire contract applies, and thus Virginia law, yes.
I think you said that in the reply brief, and I think that was said below by the trial lawyers on your behalf. But I just want to.
Right.
You don't like Virginia law, so we're going to talk about Florida law, but if Virginia, because they're going to get up and say Virginia law, until it gets to their offer judgment. But then,
right. There's one nuance to that, which is that, so there's two issues. There's the choice of law clause, whether the contract at all applies, and we're arguing that Florida law applies, not Virginia law. That's the economic loss rule, and of course we lose under Virginia's for economic loss rule. But on the second issue, which is whether the limitation of liability provision applies pursuant to section 558.0035, technically it doesn't matter for that issue whether Virginia law or Florida law applies, since both Virginia and Florida law require that unambiguous statutes be applied as written. So it's
the trial judge didn't even really address the rule on that issue, did he? Or did he or she?
Primarily it was essentially the trial court just put the cart before the horse and sort of just assumed that Virginia law applied. Right. And
I know that's the Florida statute 558.0035 was discussed in the briefs, but the judge didn't actually say, and oh, by the way, if you don't like that, you still lose under this statute.
That's my recollection. And so specifically the reason why actually an important threshold issue. Before I get into that, actually, I'll address this court's focus order regarding Southeast and the attorney's fees issue. And so the applicability of Southeast decision depends on how this court rules. And so obviously, on the one hand, if this court rules in favor of TBR, then it doesn't have to address the issue at all, because in this court's precedent, appellate attorney's fees pursuant to the proposal for settlement statute are not awardable to a appellee that doesn't prevail on appeal. On the other hand, if this court were to rule in favor of the appellees, then it would just, the court's determination that Virginia law applies, then this court would deny the appellee's motion for attorney's fees. And on the other hand, if this court found a way to apply Florida substantive law and rule in favor of the appellees, then it would grant the appellee's motion. And so it all comes down to the first issue, which I'll get to now, whether the Virginia choice of law provision is enforceable by the appellees against TBR. And so the most important...
Your best argument as to why it would not be is because they were not signatories?
Correct, because under Florida law, which indisputably applies to the threshold analysis of whether the choice of law provision applies to TBR, Florida law applies to that, and under Florida law, a non-signatory cannot enforce.
Be considered intended third-party beneficiaries?
The attended, so for my review of the record is that issue wasn't presented to the trial court. It was specifically the exception, the third-party exception that applies when the duties arise directly out of the contract. So I don't believe there's any decision of the trial court for this court to review as to the third-party beneficiary now.
But your contract, the contract basically said, both sides say, if we have a dispute about this contract and the services provided, which the two appellees were the geologists who provided, the professionals who provided the services here. We the parties, TBR and Ellis, agreed to look at each other and not look at either party's employees, etc. So you both agreed, if we were under Florida law, that we would not look at suing the actual individual people who did the work, right? Wasn't that what the contract basically said?
Well, if the contract applies, then those provisions would prevent TBR's suit. The question is whether the contract can be enforced.
Well, if you don't have a contract, these two people who were engineers who worked under the company's umbrella to provide the services and provide the report, that you would have nothing to sue upon at all, correct?
Well,
Because you're asking then for us to allow Florida law to take hold, which means the negligence action can be brought regardless of the fact that they provided these services. You can bring them individually based upon professional standards for these engineers under the state of Florida. So you're trying to say the contract is irrelevant. We're suing them just because they physically provided the service, correct?
right, and even though it's in the arbitration context, that's similar to the separate analysis by the Florida Supreme Court where they were applying the nexus test, because it's not enough for the existence of the contract to be the but-for reason that the services were performed in the first place. Instead, it has to be a situation that the case requires construction of or reference to the contract in order to determine the issues. But here, as the Moranse Court, as applied by the Witt decision in the 3rd District, explains, the professional negligence claim is external to the duty to solve this case. No reference to or construction of the contract is necessary to resolve the claims. The contract is merely just a but-for cause.
Well, your client already settled the lawsuit that it targeted against the company that employed these two engineers to perform the services, correct?
Correct.
So after that lawsuit was completed, you continued on, as you have the right to do, against these two engineers that worked for that company.
Correct.
Were they engineers or geologists?
Sorry.
Geologists or engineers?
A geologist, and one is an environmental specialist, so geologists under, essentially we're applying section 492.111, subsection 4. Right, and that's the statutory basis for the duty, which again makes it external from the contract. Because it is external from the contract, that means that the third party...
The contract is irrelevant.
Exactly. Because the contract is irrelevant and the duties arise outside of the contract, the professional negligence claim, or excuse me, the appellees cannot enforce the contract against TBR.
But your contract basically says, if we have a dispute about the services provided by those two people, the two individuals they represent, we agree that we are not going to seek any money from them. We will just seek money from their employer.
Right, and if that contract provision was enforceable by appellees against TBR, then that would prevent TBR's claims.
So you're basically saying, you two did not sign this contract. We signed a contract that said we wouldn't sue you, but guess what? You can't enforce it against us, even though we signed it and said we wouldn't sue you. Is that what you're saying?
Correct, and that flows with all of the arbitration and forum selection and choice of law.
That makes sense in the appellate world, doesn't it?
Yes, Your Honor. In all
All
those
right, go
cases where the non-signatory attempts to enforce something that a signatory has agreed to, but the non-signatory cannot, unless there is a specific exception. And so because the duties don't arise from the contract, there's no specific exception, and therefore Florida's economic loss rule applies to this case.
But getting back to what Judge Harris is alluding to, why would these people not sit? Why would not Mr. Benoit and, is it Borchert? Am I saying that right?
Yes, Borchert.
All right. Why would these two not say, because they're the ones I think drafted the proposal, and why wouldn't they say, well, that's a nice contract, our boss is really looking after us, so we're going to go do this work, and if we screw up, then our boss says the company will take care of it, and we don't have to worry about it, so we're going to benefit by this, and we're going to go ahead and do the work, and we'll do the best we can. We hope we don't do a bad job, but we're all human, and sometimes we make mistakes, and you're kind of saying, correct me if I'm wrong, you're kind of saying, well, can't really do that because you didn't sign off on it too.
Right, and that's, this is a statute, the section 558.0035 is in degradation of the common law, and it must be strictly construed. And so the fact that they, and drafting...
Just out of curiosity, I mean, the thing about the 558.0035, it says it has to be capitalized. And you agree that if you look at the contract, that one provision is much bolder than everything else. So it is a noticeable provision. It's just that the bold font is not capitalized font. Let me follow up on that. I know maybe I'm digressing a bit. I'll give you a little more time if we waste too much of your time. So if everything was capitalized in that section except the word "and" or something like that, then I guess your argument to be consistent would say, well, you capitalize every single word but one, so guess what? You guys, Benoit and Borchert, you don't get the benefit of that because you forgot to capitalize the word "and." Would that be consistent with your argument?
So, two things, Your
I
Honor.
guess the answer is yes. Did you hear what I said last time? Answer the question real quick.
Yeah.
All right.
Yeah, and
Go
so first of all, the answer is yes. CBR's position is that that would not strictly comply. Now, I anticipated that question, and so I do have a place that I don't think the court needs to go, but alternatively,
Well, I
in
drove
that,
you there, so go ahead and then we'll come back on the road.
alternative off is not capitalized or something like that. It could apply. I know it's a bad word, but it could apply the absurdity doctrine in that instance because the uppercase font was complied with, and it was a clear, formalistic, minor typo that doesn't change anything about it. Again, I wouldn't recommend going there.
The Florida Supreme Court would like us applying the absurdity doctrine and anything like that. Go ahead.
So I wouldn't recommend going there, and I would
You're not
recommend
from
just.
Tallahassee, are you? Oh, yeah, you are. Okay. Well, you
Yes,
go,
Your Honor.
You go see your friends up there and ask them about it.
And I won't get into the second
Yeah, go ahead. I'll
alternative.
give you a little more time. Go ahead.
Okay. And so, because the Florida's economic loss rule applies here, I won't get into the details because I think the parties agree based on the Tiara decision that Florida's economic loss rule does not prevent TBR's professional negligence claims.
Right.
And so, moving to the second issue, which is the applicability of the Section 558.0035 waiver issue, because as the Florida Supreme Court in cases like Eddy versus American Honda has declared that statutes in degradation to the common law must be strictly construed, this statute must be strictly construed. And it's clear it's an if-then, so it has a condition and it has a consequence. So the statute says that liability will be limited if this criteria is satisfied. And indisputably, all the criteria was not satisfied because it was not an uppercase font. And going to Chief Judge Lambert's point about the font being larger but not an uppercase, the statute actually already anticipated that because the statutory provision in the same sentence requires both the font to be larger and for it to be an uppercase font. And in this day and age, of course, if the court is ever going to find legislative intent, it has to be in the text of the statute. And the text of the statute specifically...
That's supremacy of the text thing we sometimes hear about in our court?
Yes, Your Honor. And pursuant to the Florida Supreme Court's case and larger font, this court finding that the larger font would be sufficient by itself would make superfluous the additional "and" requirement for the uppercase font. And so this court should not apply, as suggested by the appellees in their answer brief and by the trial court below, I believe, the QBE substantial compliance doctrine because two reasons. First, strict compliance is required in this case because the statute is in degradation to the common law, unlike the situation in QBE. But also, the situation in QBE is materially distinguishable as explained by the Richard versus Geico Middle District decision because in that case, the statute didn't provide any particular consequence or result for failing to put the notice in the insurance contract in QBE, whereas here, like in the Richard versus Geico decision, we have an if-then situation where there's a clear consequence. If you do X, then you get Y. And so liability is limited if you do A, B, C, and D, and they didn't do C. And so therefore, there's a clear consequence, and because unambiguous statutes have to be enforced as written, no strict compliance was had here, and therefore they cannot benefit from the waiver. And because they cannot benefit from the waiver, and because the Florida economic loss rule does not prevent TBR's claims, this court should reverse summary judgment. If there are
So,
any...
I mean, in essence, you're basically saying because if the Virginia law doesn't apply, then under the 19 Maranthus is, I don't know if I'm saying that one right.
I think it's...
I wish they just had case Smith and Jones. Right, but under that case, basically, there's exposure for the geologists and the professionals. The other fellow. So it's kind of whether we like it or not. That's the Supreme Court said so, and that's the way we go.
Right.
And so that's why you really don't like Virginia law here, because you lose, but if Florida law applies, then back to square one.
Right, and I guess I'll go into that in my 34 seconds. I'll go into that little nuance with Section 558. So unlike how I have to grapple under Florida law, which applies here for the Section 558 issue with substantial note, that Virginia applied to that specific issue because under choice of law analysis, different choice of law could apply to different issues. We would win even stronger under Virginia law. And so I will reserve the rest of my time.
All right, thank you, counsel. Go ahead, counsel.
Good morning, may it please the court.
Yes, sir.
I represent the Applees, Mr. Benoit and Mr. Borchert, with my partner, Christy Hatcher-Bolin.
Who are you?
I'm Trevor Arnold.
There you go. All right.
First of all, Your Honors, we respectfully submit that contracts matter. The right and freedom of contract is a constitutional right. And this case and the issues involving this case are very important for design professionals. Whether we're talking about an engineer, an architect, or geologist, here happen to be a geologist and not an architect or engineer, but surveyors, all of those folks fall into this large category. And commenting on where the appellant led off, non-signatories. And I'd initially like to point the court to the Deloitte case was one of the key cases relied upon by the trial court. It was the only case on this brief. We addressed it and rely upon it extensively in our response brief, and it's still sued accountants for professional negligence. So we have a claim for professional negligence against non-signatories. But there, the court ultimately held that the contract still governed those tort claims. The court indicated that it would be different if they were true third parties. In other words, if you had a restatement 552 claim where you had some unrelated lender or someone that's truly a third party. And it stressed the key criteria in analyzing whether non-signatories should be able to rely upon contract claims. Then the East Coast Karate case unpacked that.
In the final judgment, in paragraph 18 of the final judgment, the judge said the Florida courts enforce contract terms against non-signatories in situations like this case, and cites the Deloitte case, etc. That's a little different than work. I mean, that's enforcing it against a non-signatory. You guys are the non-signatories who want to enforce the contract and say Virginia law applies, economic laws, and Virginia law bars claim. Therefore, we win. Please affirm. Have a nice day. Right?
This same argument holds true, though, Your Honor, and there are Florida cases on both sides of those, whether it's, and in fact, that's what happened in the Deloitte case, is GenCorp was trying to ignore the contract, and ultimately the defendants were able to rely upon the contract and a form selection clause, and the court found that that applied notwithstanding the fact that they were non-signatories, and it's because of the three-part test. And the appellant outlines that three-prong test in their brief, and it's spelled out very clearly in the East Coast Karate case. The first prong is a close relationship between non-signatories and the signatory. There doesn't seem to be any dispute over that, given one of the people actually signed the contract, Mr. Borchert. They both were involved in the work. The second prong is non-signatories' interest or derivative of signatories' interest. And the third is claims involving non-signatories arise directly out of the contract. That seems to be the key issue that appellant is hanging their hat on. Even though they talk about the three-prong test and they don't address it, that's really the crux of their argument, is the contract doesn't matter, it's irrelevant, these claims have nothing to do with the contract. And they try to distinguish some of the cases we've relied upon, including the Citigroup case, saying that that case involved a contract claim, but it also involved tort claims. Similarly, World Vacation Travel, they say, well, that was a contract case. It included tort claims. So, and likewise, the Giller case dealt with an individual architect that was able to rely upon the contract provisions. And we respectfully submit that the same argument applies here. So why do these claims arise out of the contract? We have to look no further than the complaint itself. The complaint is replete with references to the scope of engagement and the services and the preparation of the report in conformance with that engagement. And I would point to paragraph 9 on page 4 of the record, where the complaint outlines that TBR engaged Ellis to perform this phase 1 assessment. Similarly, the allegations against Mr. Benoit and Mr. Borchert talk about their obligation to prepare this phase 1 report. I'd point to paragraph 8, page 6 of the record. And they specifically reference the need to comply with ASTM E1527, which is a 50-page ASTM document laying out how these reports are supposed to be prepared. So then if we look at the actual report, which is the crux of their claim, they're relying upon this document. Here we don't have an engineer of record or someone that prepared plans for construction. They did a pre-purchase inspection for $2,400 so this mega developer could buy this project and ultimately build apartments on it. And the report itself ties back to the contract. At page 2689 of the record, the report specifically states it was prepared in conformance with the scope of work and the contract dated February 16, 2016. Then we look at the expert opinions. They produced a standard of care expert. We had a standard of care expert, but if you look at the plaintiff's standard of care expert, he relies upon the contract for the source of duty, because you have to have a duty. It has to rise out of something. And here it arose out of the contract and the undertaking, the scope of services. And I would point to page 459, 461, 472, and 43 of the record, where Mr. Albergo specifically relied upon the contract in support of his opinions that the individual defendants didn't meet the standard of care. We know with a professional negligence claim, you have to have that standard of care testimony.
Well, let me ask, if Florida law applied here, you didn't have a provision in the written contract that Virginia substantive law applied to disputes about the services provided, would it then basically, would Morances, M-O-R-A-N-S-A-I-S, the Florida Supreme Court case, say that they are able to pursue a negligence claim against your professionals?
So in the Morances case, the court looked at the Florida statutes dealing with design professionals, and those statutes talk about business organizations and that there has to be a qualifying individual that's licensed to qualify that entity. And just because you have a business organization, it doesn't excuse someone from personal liability. So based upon that analysis, the court said that the economic loss rule is not a per se bar to claims. They didn't say the contract doesn't matter. And now we have Tierra. The Florida Supreme Court came in because people were kind of running with Morances, and the Florida Supreme Court came in Tierra and said it has to be an independent tort. So that's when the Florida Supreme Court came in after Morances and said contracts do matter. There has to be an independent tort, both in the
economic loss rule apply in products liability cases. Isn't it limited to that application, not in this application?
Yes, Your Honor, it does. And so we're not relying upon the economic loss rule. Morances still concluded that the economic loss rule is not a per se bar to claims against individual professionals. But then Tierra came in and clarified, notwithstanding the inapplicability of the economic loss rule, there's still an obligation to show an independent tort. So it's similar to the economic loss rule, but it's a different requirement of a claim to be able to present a tort claim. It has to be independent, and there's nothing independent about this tort claim.
Now, you won below because the judge said Virginia law applies, Virginia law bars the claim against your individuals. Is that not the route you're going here today, or no?
Absolutely, Your Honor. We don't have to get to Florida law because the court can, if this court agrees with the trial court. And we had multiple hearings before Judge Dees. It was actually a pretty long process where he entertained multiple briefings. We had multiple hearings, and he even indicated at some of the hearings that he was inclined to rule the other way. But ultimately, after I think the fourth hearing on this matter, he issued his opinion. We both parties submitted proposed orders in detail that were in front of the judge for several months before he ultimately reached his ruling. And he did not address in his order and his final judgment the issue of compliance with 558 because he didn't need to. And we believe that is the right outcome here, that a choice of law provision can and should be upheld And that's not inconsistent with Florida law.
And it's enforceable by your clients, even though they were non-signatories to the agreement that provided the choice of law provision.
Yes, Your Honor. And so once we meet that three-prong test, the third prong being the only one at issue, then the burden shifts to the appellant to show that this choice of law provision contravenes strong Florida public policy. And we know that's a very high bar.
Well, they really can't do that because there's a statute that says, oh, by the way, if you get the right capitalization and font, it's okay. You can relieve yourself from any personal liability. So there's not a strong public policy that says the geologist can never do that at all. So
I agree, Your Honor. And similarly, there is a statute saying you can't have forum selection clauses against contractors and require them to litigate outside of Florida. And the 5th District Court of Appeal ruled that that doesn't apply to choice of law. So the legislature knows how to say, and that's Florida Statute 47.025 in the Care Construction case.
did I write that too, or no?
No, Your Honor, I don't believe so. But I did come across a case.
And there's always a funny scenario when people quote to me about cases that I write. I usually respond, well, what did I say when I wrote it? You know, it sounds kind of inconsistent, and I wouldn't know what I wrote, but sometimes it's years ago. So,
Your Honor did have in front of you a very similar issue with out of Judge Blackwell entered an order dismissing, and we cite this in our papers, same contract language out of Orange County. It ultimately went up to the 5th, and there was a mandate. It wasn't a written opinion.
was I on that panel?
Yes, you were, Your Honor. And that's the De Rivera case. And it was the same issue. That came in after Witt, and the plaintiff in that case tried to say the contract doesn't matter. Judge Blackwell held that the choice of law provision, specifically selecting Virginia law, and there was a reason it was Virginia law here. They didn't pick that because they liked particular aspects of it. That's the home base of this firm, this engineering firm. Yes. So an additional thing I wanted to point to, Your Honor, and this was not cited in our papers. I saw it in preparing for the oral argument, but the Keystone Air Park Authority, 266 Southern 3rd, 1219.
Does counsel give a notice of the citation to that case?
No, Your Honor. I just was reviewing this last night.
I don't think we should rely upon that.
Understood, Your Honor.
Well, let me ask about the order that we issued a couple weeks ago. If we agree with your side that Virginia law applies, does Southeast Floating Dock preclude your ability to recover fees under 768.79?
Yes, Your Honor. If Virginia law applies, then we would not be able to rely upon the offer of judgment.
And Virginia law was what the trial court based your ruling on, and so if we affirmed that without explanation, then the Supreme Court says you can't get 768.79. All right,
Yes, Your Honor.
Okay.
We concede that point.
All right.
As opposing counsel mentioned, if the court found Florida law applied and we the
Right.
provision was enforceable, and so
yeah.
we wanted to preserve an argument depending upon the outcome of the appeal, but we do concede the point that if Virginia law applies under the Southeast case, we would not be able to seek fees under the offer of judgment.
Okay.
There doesn't appear to be any dispute that Virginia law would bar the claim, so I won't spend time talking about the
Yeah,
Virginia
you agree.
case law.
Yeah, I like Virginia law, but he said if you guys go with Virginia law, he loses.
So as to 558.0035, the statute requires a prominent statement. The contract clearly has a prominent
Why don't
statement.
y'all just capitalize the thing? I mean, in that same light. I mean, I know that's, in hindsight, we're always brilliant generally, but out of curiosity, non-record, have they changed their form so they don't capitalize everything as a result of this in their 558.035 paragraph?
Presumably so, Your Honor.
Maybe so.
And that was belt and suspenders.
Less heartburn there on the road.
And that was belt and suspenders to the selection of the choice of law. And it indicated that in the event it's a Florida project, then they do attempt to state compliance with 558.035. We did cite to the underlying trial court and in our appellate brief some cases that we believe support the conclusion that substantial compliance is all that is required. The argument in opposition is that this is in contravention of common law, and so it has to be strictly construed. And I respectfully submit that is not the case. It's not in contravention of common law because it's consistent with cases that have come through requiring claims to be governed by the contract. So we don't believe that this is similar to those cases, and would point Your Honor to QBE, where the font was slightly off and it still applied to protect an insurance company under the language of the statutes, and we've cited additional examples. Plaintiff's case here, the appellant's argument seems to really rest on the Witt case, which was effectively overruled or at least rendered moot by Florida Statute 558.0035, and also diffused.
That actually was the intent of the statute, the staff analysis of the legislature. I mean, I know we don't talk about staff analysis or anything else other than supremacy of the text nowadays, but that apparently was why they wrote that statute to address Witt. So. And
there was also some, it's distinguishable because that provision did not purport to apply to the individuals like our contract provisions. That provision dealt with an engineer of record for the construction of a project. And it was relying upon Morancis before Tierra came in and clarified that the independent tort doctrine is alive and well and must be followed. In conclusion, this is a sophisticated developer and general contractor. They were not only the developer, but the general contractor. That's in the record, page 681. They develop and build their projects with in-house counsel. These professional negligence claims are not permitted under Florida law. There's no cases supporting what we believe is an overreach. They're essentially trying to ignore the entire contract, even though that is the source of the duty from the complaint with respect to the phase 1 report and from their expert testimony. If that was the correct outcome, then all provisions in the contract would always be able to be circumvented when we're dealing with architects, engineers, landscape architects, surveyors, all of them. And we respectfully submit that that is not consistent with Florida law. That's not consistent with the freedom of contract and the fundamental right to have allocated risk based upon a contractual agreement. So for those reasons, we respectfully request that you affirm the trial court's ruling.
Thank you, Your Honor. We would submit that contracts do matter, and so do statutes. The contract says, pursuant to Section 558.0035, liability is waived. Therefore, because the statute requires the requirements and they failed to comply with the requirements, that's it. And so the point that my friend made about the statute not being in degradation of the common law is plainly incorrect under Florida law, because with Morancis, it held specifically that with professional negligence liability, and this is as explained by the Witt decision, professional negligence liability cannot be waived. And so under the common law, without the statute, you cannot waive professional negligence under Florida law. You need the statute. And so that is why the statute is in degradation of the common law. Contrary to my friend's suggestion, we did address Deloitte in the initial brief on page 13. And in addition to Judge Lambert's point, we pointed out that the parent-subsidiary relationship is sometimes treated differently with this exception. We don't have that here. Also, the accountants, it was a different claim or set of claims through the restatement with Section 558, different Section 558. That is different than the way Florida law clearly treats geologists and environmental professionals, which fall under a different section, Section 492.111, subsection 4. As far as the World Travel decision, that case, even though it did involve torts, all of the torts were basically just assertions of the duties that were violated with respect to the timeshare agreements that were the actual issue in the case. And the Giller decision was about the scope of arbitration, which is completely different than what we're dealing with here. That would be as if we were asking whether the scope of the waiver provision would apply here. And of course, no one contests that if the contract applies, certainly the scope of the provisions would apply to this case. but a scope issue is not presented. But then, of course, even looking to Giller, which relies on the separate decision, because the reference to the contract is not needed because the duties of professionals exist external to the contract is not necessary. So one could look to the contract. TBR could have brought a breach of contract claim, but they didn't. And the duties are external from the contract. It's sort of like, by way of analogy, assuming a plumber, right? If I contract with a plumber to put pipes into my son's house, put blue pipes, in that instance, if they put perfectly good pipes in there, but they were red pipes, if I bring a claim, then my son, who is unhappy with the red pipes, cannot avoid the contract because the only place in existence where the difference between red pipes and blue pipes matter is the duty from the contract. On the other hand, with the same contract, if the plumber comes in and puts blue pipes in, but they're too small and the water flow is problematic, then my son can avoid the contract's, arbitration clause or whatever it may be, because the duty to put in industry standard pipes is external from the contract. And so,
Plus, he got the color that he wanted to.
yes, plus you got the color. And then the law, Florida law is clear. I mean, Virginia law is clear also that, economic loss rule applies against us. But Florida law is clear that the duty for professional negligence claims is external to the contract. And this court in Loughran explained, in a different circumstance, but explained that the duty of professionals is different from the standard negligence duties or contractual duties. Let's see, there was one more point that I wanted to make. Oh, for the Morancis decision, even though it's about the economic loss rule and not applying, for example, a non-signatory issue, the reason for the economic loss rule not applying is the identical reason of the non-signatory test at issue here, which is whether the duties arise directly from the contract. And so even though economic loss rule, non-signatory exception are two different things, the reason for the Morancis decision are identical. And so therefore it applies as Witt did in the Witt decision, directly on point, though, of course, the 3rd district as opposed to the 5th district. And if there are no further questions.
Okay, thank you, counsel.
Thank you.
All right, well argued again. Good day today. All right, Mr. Martin, we'll start with you as the appellant's counsel. Why don't you introduce yourself to the students and everybody else out in the audience and tell about yourself and preparing for the case and what other stuff you think is important about it.
Yes, I'm Jonathan Martin. I work at a firm. I work out of Tallahassee, but our firm, Bishop Mills, is both a Jacksonville and Tallahassee firm. We focus on the Mills firm side of things, where I work, focuses exclusively on the appellate side of things, and so I do civil law. It's mostly commercial and some personal.
On TV?
Yeah, basically I make it so that nobody could ever enforce an arbitration clause.
There you go.
Whenever two business persons have a dispute, a lot of contract disputes, that sort of thing.
So like stuff today where we're fighting over a contract, is it enforceable or not enforceable against Mr. Benoit and Mr. Borchert? Those are things that you do. And so how long did it take you to prepare for this today? And why'd you pick this area of law?
I will
Not quite the exciting stuff you see on television here with the TV shows with trial judges and trial lawyers.
Well, I will vaguely answer the first question by saying a very long time, probably longer than everybody else, but I don't want to say specifically. And I chose this area of law because I think for me the finer points of the law are what really interests me, especially because I'm in appellate law as opposed to trial, so less of the emotion. And so I think that's what really drew me to this area of law, is the finer legal points.
Any students want to ask, or teachers, or anybody want to ask Mr. Martin about things like how long did it take you to drive from Tallahassee, or I don't know. So do you appear in front of us a lot? Or you appear in Tallahassee, the Supreme Court? Do you appear in front of the Supreme Court before?
Only during law school for an extracurricular moot court activity, not for a real case.
Yeah.
But I'm feeling I'll be appearing here more often now for change in the districts. But the 1st district, previously because of Jacksonville,
Yeah, so
Is why-
your firm's out of Jacksonville, so as well, so your cases will come more to us than to the first DCA in Tallahassee, so. Well, welcome.
We have a
to the DCA.
Thank you.
I got a question. Yes, ma'am.
Hi, what is the difference between commercial law and corporate law?
So the corporate law, which I guess I probably haven't actually had a lot of experience with other than law school, deals a lot with like mergers and acquisitions. I guess you could say that commercial law is a big umbrella, and then corporate law could be a subsection, a specific subsection of commercial law, kind of like how Catholicism could be within Christianity. I think that's right. Because, I mean, a merger and acquisition or the deals that are made there are still contract-based. They just have a particular set of law that applies.
So commercial is more like we have a contract and somebody didn't perform it, and so you're suing them and saying you need to pay me money because you didn't do the job right, or how come you won't come out and do the, things of that nature. Like here, you basically, in this case, you said, hey, you Ellis, your employees, Mr. Benoit, Mr. Borcher, didn't do a job very well, and we paid you money for the job, and because we got your work, you didn't catch everything, and so we're having a problem developing our apartment complexes here because of you didn't catch some soil condition problems.
Yep.
And so because they didn't think they did anything wrong, so you guys went to a trial, and your side is obviously the one who's unhappy with the result, and that's why you were here to ask us to say that the trial judge made an error. That's kind of what we're here about. And so we as an appellate court, we don't say, well, we don't watch the evidence or we just listen to the argument and tell us why the judge was wrong. That's primarily what our job is. Tell us why the judge was right or wrong. Is there evidence to support what the judge did, not whether we would do something different if we were sitting as trial judges in the first place. So that's kind of the difference, and that's why you guys, you're not quite as emotional as, they probably don't know who Perry Mason is if I talk about that, or Matlock, or I don't know, there was a trial there. So it's not quite as emotional here in front of us as opposed to TV where they slam on things. Well, at least we hope you don't slam on things. You probably wake up to the walls or something.
Yeah, and my wife does family law at the trial court, so it's a completely different.
I think a lot of times when they reference corporate law, you're more talking about lawyers figuring out how to structure a business structure and putting together and incorporating or creating a business. Commercial law is sometimes also referred to as commercial litigation, which would be litigation that's not based upon maybe a duty, a tort, but is based upon more breach of contract and cases kind of where you're dealing with paper commercial litigation. So if that makes sense.
I mean, you were suing these two about negligence. You're saying they didn't do their job carefully enough, and it's because of how they did their job uncarefully, if that's a word. You guys lost money, and therefore you'd like to be compensated for that, and get money from them. And they're saying, no, we did fine, and oh, by the way, you can't sue us anyways. You have to sue our boss.
Right. And I guess I should say this is a negligence case, not a contract case.
Sorry, we got that down. Aha! You caught it, didn't you? We won't hold that one against you. That was generic off the record. Any other questions from Mr. Martin before we turn it over to the other side? Yep. All right, Mr. Arnold, go ahead.
Good morning. My name's Trevor Arnold, and I'm with the law firm of Gray Robinson. I'm based out of our Orlando office. I went to undergrad and law school at the University of Florida, and I've been practicing law out of Orlando. We've got a statewide presence, and I work around the state, sometimes beyond the state, but for a little more than 20 years. I started out doing commercial litigation, so there's usually either kind of transactional, you're preparing documents, or litigation where there's disputes. So I went through an internship program, and I thought, I want to do some commercial litigation. And I gravitated towards the construction group, as even through the course of my 20 years, people continue to get more and more specialized. So now a big portion of my practice is construction disputes, whether it's contracts, fatalities, and so that's an area I kind of specialize in, is dealing with various construction matters, whether it's a building, a roadway, bridge, tunnel.
You like if a building falls down and hurts somebody, you guys, you do that?
We do have that.
I mean, you don't do that, actually, because you don't cause the problem. do that.
Crane collapses, yes.
So how much time do you spend getting ready for this case today?
I went down memory lane quite a bit. I was involved in the trial court proceedings with my partner, who's an appellate specialist. We worked on the appeal together. But even though it's only been a year since a lot of this happened, sometimes there's more time period you're looking back. But it still brought me back, down memory lane. But I'd say really over the last 2 weeks, probably 30 hours. Reviewing the cases and trying to focus and be prepared on the questions you all may ask.
Who's your partner over there?
This is Christy Hatcher-Bolin out of our Lakeland office.
I work with Trevor. I'm in the Lakeland office of Ray Robinson. I'm an appellate lawyer mostly, but I still have to do some trial work to pay the bills, basically. I work sometimes I work in federal court, but most of the time I'm working in the appellate courts of the state. And I went to Florida Southern College undergrad, and then I went to Florida State Law School. Then I went to clerk for Judge Susan Buckley in the Middle District of Florida. That's a trial level federal court.
What's the difference between federal judges and state judges? Well, I'll say that differently. Federal court and state court. How about that?
Well,
I don't know. I'm throwing it out. I never knew. So very
that's a
jealous.
loaded question.
Well, that's why I said court instead of judge. You ain't one person.
Federal courts generally, it's you either get there through what they call. You want me to talk about diversity jurisdiction? It's either.
I'm sure they'd be riveted by that. Go ahead. As we all are.
In civil cases, if you've got lawsuits between people of different states and it meets a certain dollar threshold, you can file your lawsuit. Or, and more what you usually see is if you have a cause of action that arises under the federal statute, the United States Code. But we've got lots of state law.
Most cases are state court stuff, though.
Yes.
Federal judges, they're very busy, but they don't have as many cases, right?
They do not have as many cases
Yeah.
as the state court.
And the federal court actually here is right across the street. So I pop in and say hi to your federal judge, say while you're leaving. We'd be happy to see you. Any questions? Anything about anything? How come she didn't argue today? How about that? How did that choice come through? Is that you flip a coin or arm wrestle, or what did you do?
We usually collaborate on it, and we've worked on a bunch of appeals together, and so we talk through it and kind of decide how much does this involve the underlying facts and the legal issues, and kind of make a joint decision on it.
Do you typically have two lawyers coming from to appellate cases?
Something like this, a substantial case with millions of dollars being pursued, and with the appellate specialist and with my background in the case, then we typically would.
Yeah, they don't really appreciate it. There's millions of dollars at stake here. This is just, you owe me $5,000 and we're unhappy with that. Fine. There's $1 million because of the construction that was involved, the project that's involved. So everybody spent a good deal of time and did good jobs writing briefs and getting prepared and arguing today.
Thank you very much.
All right, anything else?
Thank you, Rod.
Thank you. Appreciate you spending time talking with us. And we'll